Hello, this is Jacob Ayler with the Law Office of Riley and Ayler PC. Today, I want to talk about the ways that you can get an adoption without an individual's consent. But before I do that, as I've said in previous videos, I get a lot of emails from folks that just have questions about various legal topics, and I try to cover them in these videos. So if these are helpful, please share them with somebody. If you hear something that I talk about and you'd like me to expand a little bit more on it, please feel free to give me a call at the office. I give free consultations, so even if it's something that I may not be able to help you with directly, I'd be more than happy to answer questions, and if I can point you in the right direction, certainly do that. I received an email last week from a young lady who was recently married to a guy who had basically, even though he was not the father of her child, he might as well have been, had been with the child for many years as a father figure, and she was wanting to bring him in and basically make it official. And in this particular case, the actual biological father had been out of the picture for many years and had never developed a relationship with his child. And so, what's important to understand is there are several ways to obtain an adoption in the state of Indiana. For starters, if you have a situation where the biological father is willing to sign a consent to the adoption, that's the easiest way. So basically what happens is you file a petition with the court. The biological father signs a consent basically saying, hey, look, I understand my rights are being terminated. And generally, unless there's a big problem with either a background check issue or something like that, those pretty much always go through. However, there are several situations where if the father or mother of the child is refusing to sign a consent, it is possible that you could actually get an adoption anyways. So I want to talk about a couple of those. The first and probably the most common you run into is if the child is determined to have been abandoned by that parent. So by statute, if the parent has not had any meaningful contact with the child in over a 6-month period, then and that's, they're not calling, they're not texting, they're not visiting, those sorts of things. If you can prove that in court, then the court, and if the court agrees that you've shown that, the court could dispense with that parent's consent to the adoption. Another very common method is if there has not been meaningful contact, and this kind of falls into the realm of abandonment. Maybe the child knows the parent, but if they're in and out of their life, they're not, regularly participating in parenting activities, those sorts of things. That could be a situation where the court dispenses with consent of either the mother or the father. Another very frequent situation is if the parent has not paid child support when they have been ordered to do so. So in several cases, I've had situations where maybe the father has a child support obligation, and he's in arrears, thousands of dollars, hasn't paid child support even though he's required to. If that's the case, that can be another ground for dispensing with consent. And another very common route as well is, and it's kind of a catch-all under the statute, is if the parent is deemed as an unfit parent. And that's a very vague, and I think the legislature wants it to be very vague because there are situations where, maybe the parent is somewhat in contact with the child, maybe they're paying child support, but maybe they're just a really bad parent. For example, I had a case one time where, the father of the child had done substantial prison time for several horrible sex offenses, one of them involving the mother of the child, was a well-known drug dealer, and we were able to prove that, just for all intents and purposes, this guy was unfit to be a parent and unfit to have a relationship with the child. And the court obviously has to determine that by granting this new petition, that it would be in the best interest of the child to do so. So if you are a step parent, if this is something, or if you're the biological parent and you would like the step parent to be considered to be adopted, it's worth looking into, because sometimes you will get situations where even if that biological parent refuses to consent, simply put, under Indiana law, their consent is not always needed. And many times you can proceed with an adoption anyways. So if you would like to explore this, feel free to give my office a call, 219-866-3435. Thank you.